At Stechschulte Nell, we represent many clients that have been investigated and or arrested for DUI. In most circumstances, law enforcement will request and secure a breathalyzer result, and they have to secure two valid samples. And when they secure those samples, they want to see what is the specific reading of that sample to determine if someone is presumed impaired. In the state of Florida and nationwide, the reading is 0.08 or higher. But oftentimes there can be some varying degrees or variability with those results. For example, when you submit to a breathalyzer or an intoxilyzer, as another term for what it's known as, you are normally securing that sample an hour to an hour and a half after you're arrested. So there's a possibility that your breath alcohol or blood alcohol level may have been lower at the time you in fact were arrested. So that's an important point. Number two, the intoxilyzers must be inspected not only by the local law enforcement agency on a monthly basis, but on an annual basis by Florida Department of Law Enforcement. And what we do as DUI attorneys is we will do a public records request and review those intoxilyzer results to make sure that the sample that was used, or excuse me, that the intoxilyzer that was used was in proper working order, and to see if there's any particular issues with your results. And number three, with breathalyzers, we often see there has to be a 20-minute observation period prior to submitting to a breathalyzer, because you could secure an invalid breath sample. So for example, if you are chewing gum during that 20-minute observation, or you have swallowed mouthwash, or you have even vomited in your mouth, those things and other things can potentially affect the breath readings on a case. So that's why it's important to hire an experienced DUI defense firm like Stechschulte Nell in the event you are arrested for DUI, and particularly if you did submit to a breathalyzer.